Good morning. How are we all today? So, I'm still on the topic of terms and conditions. And yes, I know it's not the most thrilling of topics, but it is something that is so important. And of course, coming from a legal background, I used to argue over contracts all of the time. And whilst there can still be some ambiguity, I'm telling you now, if you have proper drafted terms and conditions, it makes it a heck of a lot easier. The key thing is to make sure that all of your terms and conditions are ultimately drafted by a lawyer who specializes in contract law, right? Now, I know that you can gain access on the internet for terms and conditions and I've seen this and I talked about this earlier on in the week about where I see businesses effectively cobbling something together from the internet. They see something that somebody else has got and they think, oh, that will do nicely. Now, ultimately, you do not know where their contract has come from. You don't know whether it has been drafted by a lawyer. And trust me, the lawyers can generally tell when it's been drafted by a lawyer because there is a set format. So, for example, my contract, I think off the top of my head, it's about 15 pages long. And that sounds absolutely ludicrous, but that's because I understand the key terms that are required within a contract. Now, ultimately, the whole purpose of the contract is it's setting out the terms between the parties, which includes the duties, the rights, the roles, and the responsibilities of each party. And no way can you fit that on a one page unless it's literally like a size 6 font. And this is one of the things. I don't know how many of you have gone and bought something. It could be a car or something, and you turn up and they say the terms and conditions are on the back, and it's only on one page, but it's literally you need a magnifying glass to be able to read it. Let's make it easier. Let's make it more user friendly to be able to read. So now, one thing I will say is a contract can be verbal, and I think I mentioned this earlier on in the week. However, that doesn't mean that you rely just on that, because ultimately you want those terms written down so there is no ambiguity as to, like I say, the rights, responsibilities, the roles of either party. Because ultimately, if you end up arguing over a verbal contract, I tell you what happens. If it gets into the court arena, it's a he said, she said scenario, and then it's down to the judge to make a decision as to who they believe. Whereas if you're in a situation where there is there's a written contract and there's an argument, ultimately the judge will be looking at the document that is in front of them and will be interpreting the document. And providing that contract is very clear in terms of what its intentions are by each individual clause, then it shouldn't even get into the court arena for an interpretation, because both parties should fully understand the terms, right? So let's talk about what key terms, and by no means is this an exhaustive list at all. It just gives you a few parts that you need to make sure that are included. So the first part is a definitions section, because you want to make sure it's really, really clear in terms of if there are particular phrases that you're using. So, for example, in mine, I have in terms of the program. So I'm defining, because I have an online program, so I'm defining what the program is. You're defining key things like what the term of the contract is. So if it's a 12-month term, etc., you're just literally defining key words so there is again no ambiguity as to what that specific word is meant within the rest of the contract. Then you've got things like the performance of the contract. So This is, for example, specific conditions that enable the contract to be carried out. So whether you're providing goods or services, so if it's goods, it could be well, to be honest, it could be goods or services where you're talking about things like the delivery of when those services are going to be provided, how they're delivered, any potential impact of certain circumstances which prevents the delivery. It's just about talking about how that contract is going to be performed. Of course, you've then got things like the price. Now that needs to make sure that that is crystal clear. Now, one of the things that often happens, and I highly recommend this, particularly when you're dealing with services, is you may well want to actually have a schedule or a quotation that is attached, right? And the reason why I say this is your actual pricing is likely to change depending on the specific contract that you're dealing with. So, for example, I have a number of different programs. I have a one-to-one coaching, which can vary depending on how much time and how much that monthly retainer is. You've got the online program, although that doesn't specifically change unless I'm running a promotion. And then you've also then got the mastermind. So if your terms are effectively pretty much the same across the board, doesn't matter in terms of what potential package, etc., then the schedule is a great way where that's where the actual what you're delivering changes, and having that attached can make it really beneficial. Now, the key thing with that schedule is you need to make sure that you're referring to that specific schedule within the contract itself, because what often, and this is a standard clause that should be in a contract, is effectively if there are any negotiations, anything that is prior to this document being signed or being submitted to the other party, that it excludes any other negotiations and they cannot be taken into consideration. So if you don't specifically refer to the schedule, but the schedule is a part of the contract, then you're going to be in difficulties, because you're effectively saying, well, those terms and conditions that are within that one document, because they're excluding anything else, it means it would exclude the schedule. So make sure that the terms and conditions itself refer to the schedule. Then you've got in terms of the terms of payment, right, or payment terms. So this then sets out things like the time frame from which the invoice is paid, how they pay it, whether it's by bank transfer, whether it's by Stripe, and what is the consequences of not paying on time. Are there any penalty fees? Is there interest that is charged, right? So this is where it's really important to be very crystal clear as to what the consequences are. So, for example, in my program terms and conditions, I state that I can effectively terminate or cease their access to the program for any non-payment. So that is a really key exercise. Like, for example, I used to, as a lawyer, I would state in my terms that if there was any unpaid invoice, I could cease to act for them. And this is a really, really powerful thing, because particularly when you're dealing with a legal matter, if, for example, you're dealing with a family case and there's a court hearing coming up, if you turn around and say, look, I'm going to stop acting, they need to pay your invoice for it to be able to continue, okay? Things like non-delivery, what the consequences of you not providing the service, or if you're selling goods and they're defective goods. Liability. Now, this is a really important bit. So this is where you can limit the liability, that if something goes pear-shaped with the contract, that liability is limited. What do I mean by liability? It's basically the maximum amount in which, if there is a problem, that could be claimed in relation to the contract if it got into a legal dispute. Most of the time, it's limited to the value of the contract. So that'll be your contract price. So that is a really, really important part, because if you don't limit, and obviously if it's a verbal contract, then there is no limit on the liability. So that is a really, really important part. Then you've got things like jurisdiction. What do I mean by jurisdiction? Jurisdiction means that if there is an argument over the contract, where would it be dealt with? So if, for example, you're based in the UK, then it's likely, particularly if you're based in England, that it will be within the court of England and Wales, whereas obviously if you're based in Scotland, it could be the Scottish courts, or if you're abroad, it would be whatever your local jurisdiction is. But obviously, if you're particularly based in England, you want the jurisdiction to be England and Wales. And of course, another part of all of that is the situation regarding what's called alternative dispute resolution. And what do I mean by that? It means that before it even goes into the court arena, what are the steps that have to be taken to try and resolve the dispute? So that could be anything from mediation, particularly in construction, it's arbitration, and these are all potential what's called, like I say, they're all methods of alternative dispute resolution. So they're really, really valid and important terms to have. Now, by no means have I covered every single basic term that you should have in a contract, but what that does is it just at least gives you a flavour of why it's so important to have these things written down. Because if you don't have it written down, those key terms, they're literally, it's then, it's kind of all up in the air. So you could only then rely on things like, for example, the contract price would be what the invoice is saying. Now, for example, that invoice could be a monthly retainer, but that isn't necessarily the full value of the contract price, for example. So having these things, and even on people's invoices, the amount of times I see where there is no payment terms. So if there's no payment terms, how can you then turn around and say they're late in paying? So it's so important that you make it very clear in terms of what the terms are between you and your customer. Wherever possible, you want a signature. Make sure that it is part of your onboarding process if you're particularly service-based. I know I've even been guilty, bearing in mind I've practiced as a lawyer. Sometimes it can be really, you feel like, oh, you could potentially lose the client if you then put a proper contract in front of them. And the piece of advice, and actually this is really good advice that I was reminded of recently, is if you're worried that it could put them off, is arrange a meeting with them where you can actually sit down and talk through the key things so that they aren't then intimidated by it. Because like I said, if you have a proper drawn out contract, you will be in a much better position. It means everybody who's involved in that contract will know exactly where they stand, and it reduces the risk of any arguments in the future. So I hope you've gained some real benefit today in terms of the terms and conditions. If you do not have terms and conditions in place, then please do DM me. Whilst I do not draft bespoke terms and conditions, I do have some templates that are available within parts of my program, for example, that you may well benefit from, depending on the industry that you're specifically in. But I do have some terms and conditions that I can help you with, or I can at least steer you in the right direction of a great lawyer who can draft them for you. So make sure you send me a DM, and I'd love to get your thoughts in terms of what I've talked about today. Do you have, share in the comments whether you've had your terms and conditions drafted by a lawyer, where have they come from? Are there any key terms that I've not talked about that you've kind of relied upon in the past? Love to know your thoughts on this. So thank you guys for listening. It's been a bit longer than normal, but hopefully you've got some real value, and I will see you very soon.